This is my lecture fifth. Again, on the remaining part of the topic of dower or maher under Muslim law. Uh, Today I will discuss widow's right of retention, the property of the husband in lieu of unpaid amount of the dower. So this is the point of discussion for today, that is widow's right of retention. I have already pointed out in my previous lectures in context of maher or dower under Muslim law that it is sum of money or other form of the property paid or promised to be paid by the husband to his wife as a gift in consideration of the marriage on the conclusion of it. I have also pointed out that dower may be specified, that is, that it may be mentioned at the time of the solemnization or formation of the union of the marriage. And while fixing the amount of the dower, parties may also agreed upon what portion of the fixed amount of the dower will be prompt and what part of the specified dower will be deferred, that is payable uh, in future on the happening of a specified event. Ladies and gentlemen, it must also be clear to all of you that when any part of the specified dower is made prompt, it means it becomes payable immediately on the demand of the wife, and the husband must make the necessary arrangement for the payment of it immediately as and when demand is placed by the wife for its payment. However, if there is a demand for the prompt dower and same is not paid by the husband, wife will be entitled to enforce it by refusing to cohabit with the husband. And in case the husband files a suit for the restitution of the conjugal right, where the wife has deserted the matrimonial home and amount of the dower, prompt dower, has not been paid, then the court may pass a decree for the restitution of the conjugal rights, subject to the condition that husband will make the payment of the dower immediately pursuant to the decree for restitution of the conjugal right. So this is one of the way for enforcing the prompt dower, that in case demand for prompt dower is made and husband fails to pay it and still marriage is unconsummated, the wife will be entitled to refuse to cohabit, even can leave the matrimonial home until the amount of the dower, prompt dower, is paid to her by her husband. So that is the refusal to cohabit with the husband is one of the way to enforce the payment of a prompt portion of the dower by the wife against the husband. However, sometime a certain part of the specified dower may be deferred, and deferred means the payment is postponed for future, and it becomes payable only on the happening of a specified event, that may be that is the dissolution of marriage by death of the husband or by divorce. Meaning thereby that where certain part of the specified dower is deferred, it means that it will become due and payable to the wife by payable to the wife only on the happening of a event, specified event, that is on the dissolution of marriage. Dissolution of marriage may take place by the death of either spouse or by the death of the by the divorce, that is the dissolution of marriage. In any case, a deferred portion of the dower becomes payable but to the wife only on the happening of the dissolution of the marriage. Uh, the unpaid amount of the dower of the wife, however, is not better than unsecured or claim of any unsecured creditor. Therefore, during the lifetime, widow can recover, a wife can recover the unpaid dower from her husband, failing which uh, it can be recovered from the property of the husband. In the event of divorce, however, if the husband has died and dower is unpaid, of course, in that very situation, the widow will be entitled to realize it from the property left by the deceased husband. If she predeceases the husband, the heirs of the deceased wife will be entitled to recover it from the property of the deceased husband. However, in case there is a dissolution of marriage by death of the husband and amount of the dower is unpaid, certain part of the dower is unpaid, it is pending, the payment is pending, then in that very situation, wife will be entitled, still the widow will be entitled to uh, have it realized, and she will be entitled to realize it again from the estate of the deceased. But wife or the widow, that is in case of the death of the husband, if the amount of the dower is pending, is unpaid, then in that very situation, Muslim law gives the widow whose dower has remained unpaid a very special right to enforce her right, and this right to enforce the unpaid dower against the property of the deceased husband is known as widow's right of retention. Now the point is, what is the widow's right of retention? This is a legal expression, legal proposition. Widow's right of retention. Rule is that if a Muslim wife during the lifetime of the husband is in the exclusive possession of the property or a part of the property of her husband, or in other words, if a wife during the lifetime of the husband has acquired possession over the property or part of the property of her husband, she on the death of the husband has right to retain and continue the possession over such property until her entire amount of the unpaid dower is fully satisfied out of the income of the property in her possession. So, this right to retain and continue the possession over a property of the husband which was already in her possession, this widow's right to retain the possession over such property of the husband in lieu of the maintenance, in lieu of her unpaid dower, is known as widow's right of retention, provided possession over the property in question was acquired during the lifetime of the husband, and it was acquired during the lifetime of the husband not by force, fraud, misrepresentation, but it was obtained by the wife, or it was acquired by the wife lawfully and peaceably. Therefore, when a widow is shown to have been in the possession of her husband's property in his lifetime, and for some time after his death, property, uh, the law will presume possession over the property was acquired lawfully and peaceably, and the widow will be entitled to retain the possession over the property in lieu of her unpaid uh, amount of the dower until the entire debt of the dower is fully satisfied. If a Muslim widow entitled to a dower has not obtained the possession lawfully, peaceably, she cannot have the widow's lien by taking the possession over the property adversely to the other heirs. The widow can retain the possession over the husband's property only in lieu of her unpaid dower, not for some other reasons. Means that if a widow is in the possession of certain portion of the property of her husband, and she acquired possession over it during the lifetime of the husband, there is a death of the husband, amount of the dower is unpaid, certain part of the dower is still unpaid. In that very situation, the widow, now the wife who has become widow on the death of the husband, she will be entitled to not retain and continue the possession over the property of the husband until her entire amount of the dower is satisfied. Therefore, a right of retention of husband property in lieu of her unpaid dower or maher arises for the first time on the termination of the marriage, either by the death of the husband or by divorce. Therefore, the right of retention over the property of the husband in the possession of the widow or divorcee will not arise during the continuance of the marriage. If marriage is still in existence, still subsists and continue, relationship of the marriage subsist and continue, and wife is in the possession of certain portion of the property in lieu of her amount of the dower, she can be deprived of it at any point of the time, she can be dispossessed of it on the payment of the amount of the dower or for whatever reason, and therefore she will not be entitled to retain the possession over the property on such property during the continuance of the marriage. Because the right of retention is simply the right to continue the possession, not the right to obtain the possession. Thus, if the property may not be in the possession of the widow during the lifetime of the husband, she cannot obtain its possession after the death under this right. The right of retention also does not give a title to her. It is also not a legal charge on the property, and therefore, in the exercise of the right of the retention, the widow cannot alienate the property by way of sale, mortgage, and gift, etc. The right of retention is extinguished on the payment of dower, unpaid dower, or on the clearance of the dower debt. This can happen in two ways. She can satisfy her claim for a dower out of the rents and profit of the property which she is retaining, or on the payment by the heirs of the uh, deceased of the dower proportionate to their shares for the recovery of their respective shares. So here it should be crystal clear that widow can retain possession over the property of her husband, and she can continue it uh, unless and until her entire amount of the dower is satisfied. The dower can be satisfied, the amount of the dower can be, the wife can realize or can be satisfied for the unpaid amount of the dower in two ways. That is, she can be paid by the legal heirs the unpaid amount of the dower in the ratio in which their property, portion of the property in her possession. And once the amount of the dower is paid to the widow by the legal heirs, thereafter her right to retain the possession over the property will come to end, will cease to exist. Say for example, W is the widow of M. M has died without paying the uh, amount of the dower. During the lifetime of M, she has acquired possession over certain part of the property of her husband M. Acquisition of possession over the property was lawful and was also peaceful. Lawfully, the property was acquired by the wife in the lifetime of the husband M, and he has died without paying the amount of the dower. Say for example, it was rupees 50,000. After the death of the M, the widow W will be entitled to retain possession over the property of her deceased husband, and she will be entitled to continue over such property in possession unless and until her entire amount of dower, that is rupees 50,000, is uh, realized or satisfied. Now, if M has left behind two legal heirs entitled to succeed the property of the deceased M, then the legal heirs, say for example, they are C and D. Now, if they want that property in the possession of the widow should be released by her, they will be required to pay the entire amount of the dower to the W. She will be required to pay 25,000 of his share, and she will be required. D will be required to pay his share, which is 25,000. As soon as both the legal heirs of that M, they satisfy to the widow by paying her entire unpaid amount of the dower, thereafter uh, they will be entitled to have the property released from the possession of the widow, and the widow's right of retention will cease to exist and continue, and her right will come to an end, and the property will go to the legal heirs of the M, who are C and D in the given circumstance. However, if the payment is not made, then the widow will be entitled to retain the possession over such property. W will be entitled to retain the possession over this property, and she will continue to retain the possession over the property until rupees 50,000 are realized from the property in question in her possession, that is rupees 50,000. As soon as rupees 50,000 are realized from the income or proceeds of the property in her possession, her right to continue the possession will cease to exist, and property will go thereafter to the legal heirs of the deceased M. It may also be noted that during the retention of the property in question for the realization of unpaid amount of the dower by the widow, she will not at all be allowed, or she is not at all allowed by the law to alienate the property either by way of gift or by way of sale. It is a mere right of retention in lieu of the unpaid amount of the dower. It does not create any lien over the property. It does not create any kind of the title in the property in the possession of the widow in lieu of the maintenance. Further, that widow can retain possession over the property of her husband only in lieu of the in lieu of the unpaid dower, not for any other reason. And therefore, it is only the right of retention, not right of obtaining the possession of the property which was not in the possession of the widow for realization of her unpaid amount of the dower. Humaira Bibi versus Zubaida Bibi case, a question came for consideration for judicial disposition. What is the nature of widow's right of retention? The Privy Council Humaira Bibi versus Zubaida Bibi case, explaining the nature of widow's right of retention over the property of her husband. Dower is an essential incident under Muslim law to the status of marriage. The dower ranks as a debt, and wife is entitled along with other creditors to have it satisfied on the death of the husband out of his estate. Her right, however, is no greater than that of any other unsecured creditor, except that if she lawfully, with the express or implied consent of the husband or his other heirs, obtains possession of the whole or part of his estate to satisfy her claim with the rents and issues accruing therefrom. She is entitled to retain such possession until it is satisfied, and this right is called or is known as widow's lien for dower over the property of the deceased husband. So here it was made very much clear by the Privy Council in Humaira Bibi versus Zubaida Bibi case. The court made 2 points ample clear. One thing, that dower is essential incident arising to the status of the marriage, and therefore wife is always entitled to receive it or entitled to have realized it as a wife after the marriage. This is the exclusive right of the wife of a marriage, and therefore, being the exclusive right, wife is always entitled to receive it from the husband. In the absence of the husband, this will be treated, the unpaid dower will be treated as a debt running over the property of the husband, deceased husband. However, the Privy Council clarified that the nature of unsecured debt of the dower in no way is superior than any other unsecured creditor of the husband, except that where the widow is already in possession of certain part or portion of the property of her husband, she will be entitled to retain possession over such property after the death of the husband until her entire amount of the dower is fully satisfied out of the rents, profit or income of the property in question. The Privy Council also clarified that the prerequisite for retaining the possession over the property in question of the husband by the widow in lieu of her unpaid dower is that it must have been acquired by the widow without force, without fraud, without any misrepresentation. Rather, it should have been acquired lawfully and peaceably. What is lawfully and peaceably? According to the Privy Council, to be regarded possession obtained peacefully, it must be shown that it was obtained during the lifetime of the husband either with his consent or with the consent of his other legal heirs. The second thing is that it is only a widow's lien over the property. It does not create any title, and therefore she does not become owner of the property in question simply because of having the possession over it. Therefore, this right is lost. This right of the widow, that is the widow's right of the retention, is lost the moment amount of the dower is satisfied from the income of the property in question. Thereafter, she will not be entitled to retain it, and if retention is continuing even after the satisfaction of the unpaid amount of the dower, it will amount the illegal possession or adverse possession over the property in question. Uh, Again, in Maina Bibi versus Chaudhary Wakil Ahmed, the nature of widow's right of retention came for consideration, and same are discussed by the Privy Council in this case at length. In brief, the fact of this case is that there was Moinuddin. Uh, he was married with a woman, Maina Bibi. Moinuddin died in 1890, and his widow Maina Bibi was in possession of certain part of the property of her deceased husband. After the death of the husband, the widow Maina Bibi uh, retained the possession over the immovable property of deceased husband in lieu of her unpaid dower. And during the continuance of possession over the property in lieu of the maintenance, widow this Maina Bibi attempted to make a gift of property in her possession, which was challenged. Plaintiff challenged this gift, and Privy Council held that widow had no power to make a gift of property or properties which was in the possession of the widow Maina Bibi in lieu of the unpaid amount of the dower. It was further held that possession of the property being once peaceably and lawfully acquired, the right of the widow to retain it till her dower debt is paid is conferred upon her by Mohammedan law. Meaning thereby that Mohammedan law or Muslim law allows a widow to retain the possession over the property only for the purpose of realizing her unpaid amount of the dower. But during the continuance of the possession of the property, she has no right to dispose of or alienate the property by way of sale or by way of gift, because sale of the property can be made only when one is holding a lawful title over it. Gift can be made only when the donor is having the title over the property. Lawful title here means lawful title. Here, where the property is retained by a widow in order to realize her unpaid amount of the dower, this right does not create any title over in the property, and therefore it will be unlawful to dispose of or to alienate the property by way of sale or by way of the gift. And therefore the court further said that it is not exactly alien nor a mortgage, and the widow who holds the possession over her husband's property until she has been paid her dower has no estate or interest in the property as has a mortgagee under an ordinary mortgage. Then again, in case of Kapoor Chand versus Qadrun Nisa Begum and others, a Supreme Court of India held that a Mohammedan widow in possession of her husband's estate in lieu of her claim for dower with the consent of the heirs, uh, otherwise is not entitled to priority as against his other unsecured creditors. There is nothing inherent in every nature of dower which entitles priority to the widow. Here there are two major questions on which law is still unsettled: whether the right of retention is transferable, whether right is heritable, There is conflicting of judicial opinions on these points. One view is that right is personal in nature, therefore it cannot be transferred by sale, gift, otherwise. I have already explained with the help of earlier decisions. The other view is that right to hold the possession is property right, therefore it is transferable. There is a third opinion which holds that it is both transferable and heritable. Uh, in Maina Bibi case, Privy Council expressed the doubt whether widow could transfer either the dower debt or right to hold the possession. All that now can be said with certainty uh, in the light of Maina Bibi case that right to hold the possession is only heritable right, not transferable right. Allahabad High Court has decided that right is both heritable and transferable. But Patna High Court has held that right is personal in nature and not alien, therefore not transferable. However, the bias authority seems to be in favor of the Patna High Court, uh, since the view of the Patna High Court on the point is in consonance with the view judicial opinion expressed by the judges in Maina Bibi versus Chaudhary, in Maina Bibi versus Wakil Ahmed case, wherein it was held that it is only a right of, it is only a heritable right but not transferable right. Uh, mm, and it is also well established from the uh, other authorities on Muslim law that it is a mere heritable, not transferable right. But still, a final decision from the from the Supreme Court on the question whether it is transferable or not is awaited and may be given by the Supreme Court sometime in future when the matter comes for consideration, whether it is transferable or heritable. Final decision or verdict may come from the Supreme Court of India at appropriate time in appropriate case when it comes for decision before it. Uh, Thank you very much.